We have two cases here, both involving the same defendant, State of Ohio versus Brittany and Henry. Principal State's Assistant Prosecutor King, Principal Defendant's Attorney William C. Parker, and are you Brittany and Henry?
Yes.
Right, in case number 22 CR 12, Ms. Henry is charged with aggravated possession of methamphetamine, felony. Case number 22 CR 403, she's charged with 3 counts of aggravated trafficking methamphetamine, 1 in the vicinity of the school zone, 3 counts of aggravated possession of methamphetamine, and forfeiture. Specification. This is a final pre-trial, probably December 28th. I've been presented with a plea, guilty form messed up, Henry, which indicates that you're going to withdraw your not guilty plea in each of these cases and enter a plea of guilty in case number 12, 22 CR 12, to the indictment, sole count aggravated possession of methamphetamine, and in case number 22 CR 43, count 3 of aggravated trafficking of methamphetamine in the vicinity of the school zone and aggravated trafficking of methamphetamine, count 5. Now, each of these documents are prepared by the prosecutor's office from a template they have in their computer. In case number 22 CR 12, there is a sentence about halfway down the third page. It says, "Enter this plea voluntarily." And underneath that, there's a signature line. It says, "Signature defendant," print below it, and I see what appears to be Brittany Henry. Then on 22 CR 43 case, it's 4 pages, and the sentence is right at the very top of page 4. It says, "I entered this plea voluntarily." Immediately below that's a signature line, signature defendant, Brittany Henry. Now, did you sign these 2 agreements I'm looking at?
Yes, sir.
When did you sign?
I'm not exactly sure on the date. A week ago at least.
Okay. Was that at the jail where you signed?
Yes.
And was Mr. Parker there with you to go over that when you signed it?
Yes, sir.
Did he explain everything to you and answer all of your questions?
Yes, sir.
And you understood that when you signed these agreements that they're agreements to plead guilty, which means there won't be a trial, and the next step in your case would be a sentence.
Yes, sir.
And did you have enough time to fully consider this matter before making this decision?
Yes, sir.
And you decided that even though you signed these agreements a week or so ago, that this is still what you want to do here today.
Yes, sir.
All right. Now, on case number 22 CR 12, as I indicated, you're going to plead guilty according to this form to aggravated possession of methamphetamine under 292511 of the Ohio Revised Code 53 felony. And it states that you understand that the maximum prison term for that could be 12 months in prison. Then it could be 6 if the prison term is imposed. It could be a fine of up to $25. There could be a license suspension 6 months to 5 years. You understand that?
Yes, sir.
Now, in case number 22 CR 43, the form says, plead guilty to count 3, aggravated trafficking of methamphetamine in the vicinity of the school zone under 2925.0381, a first degree felony. And count 5, aggravated trafficking of methamphetamine under 2925.0381, a third degree felony. Now, with regard to count 3, you indicate that you understand that the maximum possible prison term for that could be 11 years. The minimum would be 3 years. There could be a fine of $20,000 and a mandatory fine of $10,000 and possible license suspension 6 months to 5 years. And in this case, that is a mandatory prison term. Or the judge selects for someone who's convicted of this offense, selects a minimum term of anywhere between 3 and 11 years. And whatever that number is, must be served. Now, under the law for this offense, a first degree felony, the Department of Rehabilitation and Corrections does have the authority to determine that a person convicted of this type of offense should serve more than the minimum sentence imposed by the judge. And so they could extend the sentence by up to 1/2 of whatever term was ordered by the court. So, for purposes of understanding the maximum penalty, since the maximum penalty is 11 years, actual incarceration ordered by the judge, that could, depending upon the DRC, be extended to as much as 16.5 years. The minimum would be 3, and half that would be 4, or 1.5. So that means that there could be a minimum, or a sentencing range of between 4.5 years and 16.5 years on that count. You understand that?
Yes, sir.
Now, count 5 is a third-degree felony, and it has a sentencing range for prison of between 9 and 36 months. And there are certain increments that goes from 9 to 12, and that's 6 months, every 6 months up to 36 months. There's a fine of $10,000, a mandatory fine of $5,000. And again, each of these carries a possible license suspension between 6 months and 5 years. Do you understand that?
Yes, sir.
Now, under the law, if you're convicted of all 3 of these offenses, the court could order the sentences to be served consecutively, meaning one after the other. So, in order to inform you of the worst case scenario, 12 months is the worst possible sentence in 22 CR 12. 4.5 to 16.5 on count 3, and the 22 CR 43 plus 36 months, which is 3 years. So if you add all those together, the minimum sentence would be 3 years is what's a minimum possible, because that's mandatory on count 3. But if the court imposed all sentences consecutively, maximum, that would be 12 months plus 36 months, which is 48 months, plus 11 years. So that's basically 15 years as a minimum. Would be what the court could sentence, with the possibility of extending the sentence on count 3 of the aggravated trafficking, methamphetamine, and sending to school to up to 16.5 years by the Department of Rehabilitation and Corrections. So that's the worst case scenario for you in the term of incarceration. And then the court could also fine you a total of $32,500 total between the 3 charges. Do you understand that?
Yes, sir.
Other than these charges, Ms. Henry, are you facing any felony charges anywhere else?
No, sir.
Are you currently on community control, probation, parole, or post-release control for felony?
No, sir.
Now, in case number 22 CR 12, there is a possibility of community control, but there isn't on the, and also on the count 3 or count 5 in the 22 CR 43 case. And so what that means is that instead of sentencing you to prison, the court will put you under supervision of probation officer on a term set by the court for a period of up to 5 years. If during that period of time the probation department found that you were not complying, it would file a written notice out with the court. It would be given a copy and have a hearing, and would be entitled to have an attorney to represent you at that hearing. The outcome of that hearing was that you had failed to comply, and at that time the court would revoke community control. In case number 22 CR 12 sent you to 12 months. In case number 22 CR 43 sent you to 36 months. Again, this is only as count 5, which would be a total of 48 months plus a fine of $12,500. Do you understand that?
Yes, sir.
Now, under the law, you will be sentenced to prison if you plead guilty to count 3, and so therefore you'll be sentenced to all of it. The law provides that once you complete prison term for a first-degree felony drug offense, it is mandatory that upon completion of the prison term, that the defendant be put under post-release control supervision under the authority of the adult parole authority for a period of at least 2 years, up to a maximum of 5 years. It means you'll be supervised by a parole officer on the term that they set, because the judge has nothing to do with that. And if they determine that you have failed to comply, then they can return you to prison, making serve an additional period of up to 9 months for the 1 violation. But there is a cap of half of the prison term that is imposed for all violations. But if you commit a new felony upon the post-release control, then in addition to whatever sentence the judge in the new case imposed upon you, that judge is also authorized to sentence you in this case, or in these 2 cases, for committing that new offense while under post-release control in these cases, to an additional period of 1 year or whatever time would be left on whatever post-release control term was imposed, whichever is greater. And if that occurred, then be served consecutively the sentence in the new case. You understand that?
Yes, sir.
Now, it may seem silly for me to tell you this, but unfortunately I've been told this is what I have to do by the Court of Appeals, and that is, we know that if you are convicted of the third count, you will get post-release control for a period between 2 and 5 years. On the other 2 counts, it's optional, meaning it could be up to 2 years, as determined by the APA. But we know you're going to get the 2 to 5 on count 3, but they could decide to give you additional period of up to 2 years of optional post-release control on the other 2 cases with the same consequences I mentioned earlier. That if you've been a violation, they can return you to prison for up to 9 months for a single violation, up to a total of 1/2 of the prison term for all violations. And again, if you've been a felony while on post-release control, the same possibility is that you can get an additional 1 year or whatever time left on that period of post-release control, whichever is greater, would have to run consecutively to the new sentence. You understand that?
Yes, sir.
All right. In case number 22 CR 12, charged with aggravated possession of methamphetamine and alleges that on or about May 11, 2021, in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine. Violation section 2925.11. So that's the 5th degree felony, 6 to 12 months, 25 to 1 and possible license suspension, 6 months to 5 years. Count 3 alleges in case number 22 CR 43, and on or about October 1, 2020, in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, amount equal to or exceeding 5 times the bulk amount, less than 50 times the bulk amount, in the vicinity of the school zone, violation section 2925.0381. That's the first degree felony. As I said, carries a mandatory sentence of between 3 and 11 years as set by the judge. Possibility of that being extended by up to 1/2 by the DRC. A fine of $20,000, mandatory fine of $10,000, possible license suspension 6 months to 5 years. Count 5, in 22 CR 43, alleges that on or about February 18, 2021, Highland County, Ohio, he did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount less than 5 times bulk amount, violation section 2925.0381. So that would be the 3rd degree felony, and possible prison term between 9 and 36 months under the influence provided by law. Fine of up to $10,000, mandatory fine of $5,000, and a possible license suspension 6 months to 5 years. Now, Ms. Henry, do you understand what it is you've been charged with in each of those counts, what the state said you did, when, where, and how they alleged you did each of those?
Yes, sir.
You discussed the nature of each charge, the evidence in the case, the legal issues in the case, possible defenses to be raised in each case, and possible outcomes of a trial in each case with your attorney.
Yes, sir.
I'm sorry?
Yes, sir.
And are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any are you taking any prescription drugs?
No, sir.
Have any threats been made against you to plead guilty here today?
No, sir.
Now, on page 2 of each form, there are some lines that are printed in bold and underlined. Case number 22 CR 12, that reads, the bench shall plead guilty to the indictment. State defense jointly recommends 6 months incarceration consecutive to 22 CR 0043. In the 22 CR 0043, it reads, defendant shall plead guilty to counts 3 and 5. State will dismiss remaining counts. State defense jointly recommend 3 years mandatory on count 3, consecutive to 36 months on count 5, and consecutive to 22 CR 12. Defendant shall cooperate fully with the task force. Defendant will pay $1,520 as consideration for a plea agreement. That's restitution, right?
Yes, sir.
I think that needs to be in there. That restitution. Yeah. I know, I understand what it means, but somebody might look at that and say, what's this? No. Yeah. Is that your understanding of the agreement in each case?
Yes, sir.
And there's stipulation as to the amount of restitution, Mr. Parker, $1,320.
Yes, sir.
Okay. Now, has anyone promised you anything other than what I just read you to get you to plead guilty here today?
No, sir.
Right now, Ms. Henry, under the law, the matter of sentence is up to the judge, not to the parties. And so even though there's an agreement between you and the state as to what the sentence in each of these cases should be, the court's not obligated to follow that. So if you plead guilty, once I've heard all the information submitted, if I decide that's not the correct sentence, I could sentence you to as much as 12 months in the 22 CR 12 case, as much as 11 years in count 3, and as much as 36 months in count 5, plus fine you and suspend your license. You understand that?
Yes, sir.
Okay. Now, do you hold any license or certificate from any state agency that regulates any kind of a profession or occupation.
Yes, sir.
Right now, you have certain constitutional rights, which I understand, Ms. Henry, before I can accept the pleas in this case. First of all, you do have a right to have counsel. You employ Mr. Parker to represent you. Now, under the law, if you did not have the funds to hire an attorney, the court would appoint an attorney for you to represent you. And so the reason I ask that question is I want to make sure that you're not entering into this agreement to plead guilty because you're worried that you're not going to have enough money to continue to pay Mr. Parker. Is that a problem?
Well, I'm being broke, but it's,
I mean, you're not pleading guilty because of that.
no, yes, sir.
Gotcha. All right. Now, you have a right in each of these cases to have a jury trial in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial day. After they are selected, the evidence will be presented. The judge will instruct that jury in each case on the law. And then the jury in each case would have to decide by unanimous verdict, meaning all 12 would have to agree as to whether or not the state proves your guilt on any of the charges. Now, if you decided you didn't want to have a jury trial in either or both cases, but you didn't want to plead guilty, then you can sign a written waiver of right to trial by jury. What that means is waiver means that you are giving up the right to have a jury trial. And then in that case, you could have what's called a court or bench trial, meaning the judge would be the one to hear the evidence instead of the jury. The judge would apply the law, and the judge would decide whether or not the state proved your guilt or proved beyond reasonable doubt on any of the 3 charges. You understand that?
Yes, sir.
Now, in each of these cases, you have a right to confront the witnesses against you, cross-examine them through your attorney. What that means is that in each case, the witnesses against you have to come into the court and testify in open court, public, in front of you, your attorney, and everyone else is present. After the prosecutor is done asking those questions, and includes the witnesses' questions, your attorney can ask questions. That's called cross-examination, the purpose of which is to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court to testify for you, the same as the state. So if you have witnesses you're uncertain going to come in voluntarily, your request for issue of court order is called a subpoena, and that forces those witnesses to come to court and be able to testify if you want them to, even though they don't want to be here. And that's the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, sir.
Right now, under the Constitution, Ms. Henry, you have in each of these cases a privilege against self-incrimination. What that means is that you cannot be forced to give evidence or to testify in either case. No one there can testify. The prosecutor can't, the judge can't, it's your decision. And if you decide you're not going to testify in either of those cases, the fact that you did not testify cannot be used against you in either case by the jury or anyone else. And in fact, no one's even allowed to talk about it except in one situation. That is, if there's a jury trial in either or both cases and you elect not to testify, the fact that you did not testify, the court instructed the jury that the fact that you did not testify is because that is your constitutional right and that they cannot consider it for any purpose in that case. You understand that?
Yes, sir.
Right now, in each of these cases, Ms. Henry, you are presumed innocent until proved guilty by the state of Ohio on every essential element of each of the offenses. So what that means is that the burden of proof isn't on you to try to prove that you're not guilty simply because you've been accused of this crime. In fact, under the law, you don't have to put on any evidence in your defense in either case. You may, but you're not required to. But whether you present any evidence in your own defense or not, the burden of proof in each case will remain upon the state. Prove your guilt of that charge or charges in that particular case by proof beyond a reasonable doubt on every essential element. That's the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Right now, originally you entered pleas of not guilty in these cases. That plea denied the allegation in each case of all allegations, and it exercised or revoked all of the rights that I've just described for you here today. Now, if you change your plea from not guilty to guilty to the charge in 22 CR 12, counts 3 and 5, and 22 CR 43, that's the opposite of the not guilty plea. Guilty plea admits the allegations that you have and admits their crime that you committed that crime. And that plea waives up all the rights that I've described for you this afternoon, except the right to have an attorney. You have the right to have an attorney no matter what you plea. With that exception, your plea of guilty waives up the right to a jury court trial, gives up your right to confront the witnesses against you and to cross-examine them for your attorney, gives up your right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state, wagers up your privilege and self-determination, because if you say you're guilty, that's what you find you guilty in each case. And it wagers up your presumption of innocence in each case, because if you say you're guilty, then the state doesn't have to prove you're guilty of anything in any of those cases, because that's the plea guilty is proof. Subjection being sentenced immediately by the court.
Yes, sir.
And do you have any questions about the charge or charges in either of these cases?
No, sir.
You understand the charges?
Yes, sir.
You understand the possible penalties for each of those charges?
Yes, sir.
Do you have any questions about the plea agreement in these two cases?
No, sir.
You understand it?
Yes, sir.
And again, you understand the recommendation as to sentence is not binding on the judge.
Yes, sir.
Do you have any questions about the constitutional rights of this plan?
No, sir.
You understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
You understand?
Yes, sir.
Is there anything you'd like to speak to your attorney about before we go any further?
No, sir.
Do you have any questions about anything I've explained to you here this afternoon?
No, sir.
That is, it's your decision to withdraw your not guilty plea in these two cases, plead guilty to the single count of 22 CR 12 and 2 counts 3 and 5 and 22 CR 43, pursuant to the terms of the plea agreements that we've gone over for these cases.
Yes, sir.
All right, and as to the charge, in case number 22 CR 12, it's alleged in honor about May 11, 2021 in Hyman County, Ohio. You didn't knowingly obtain, possess, or use a Schedule 2 controlled substance methamphetamine, violation of Section 2925.11 of the Ohio Revised Code, a 5th-degree felony carrying a possible prison term between 6 to 12 months, fined up to $2,500, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
As to count 3 in case number 22 CR 43, which alleges in honor about October 1, 2020, in Hyman County, Ohio, you did knowingly sell or offer sell methamphetamine, a Schedule 2 controlled substance, amount equal to or exceeding 5 times the bulk amount, less than 50 times the bulk amount, vicinity to school zone, violation of Section 2925.03A1, charge of aggravated trafficking in methamphetamine in the vicinity to school zone, a first-degree felony carrying mandatory prison of between 3 and 11 years is set by the judge, the maximum of up to 1/2 of that term set by the judge being added by DRC, a fine of up to $20,000, a mandatory fine of up to $10,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
Then as to count 5, which alleges that on or about February 18, 2021 in Hyman County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule 2 controlled substance, an amount equal to or exceeding bulk amount, less than 5 times bulk amount, violation of Section 2925.03A1, the charge of aggravated trafficking in methamphetamine, a 3rd-degree felony carrying possible prison term between 9 and 36 months in increments provided by law, a fine of up to $10,000, a mandatory fine of $5,000, a possible license suspension of 6 months, 5 years. How do you plead?
Guilty.
All right, court finds on this day in open court, defendant was advised of all of our constitutional rights, made a known, intelligent, voluntary waiver of the same, pursuant to Criminal 11. Pleas are accepted and ordered upon. Defendant is found guilty in case number 22 CR 12 of aggravated possession of methamphetamine, a 5th-degree felony is charged therein. And in case number 22 CR 43, she's found guilty of count 3, aggravated trafficking methamphetamine in the vicinity of school zone, 1st-degree felony is charged therein. And count 5, aggravated trafficking methamphetamine under 2925.03A1, and 3rd-degree felony is charged therein. The remaining counts are, would be counts 1, 2, 4, 6, and 7 are dismissed. All right, now inasmuch as this is a count 3 and 22 CR 43 is mandatory prison term, there has been a recommendation by the parties. The court will go ahead and proceed with sentencing. Anything from the state regarding sentencing?
Only one thing to say, Your Honor.
All right, Mr. Parker.
Your Honor, just briefly, Ms. Henry is 36 years old. She has no prior criminal history. She's extremely remorseful for her actions. I'm sure Your Honor has seen her fight back tears today, and that has been her demeanor when I've met with her on a couple other occasions. She understands her impact that she's had on the community. looking at the purposes of principle of sentencing to properly punish Ms. Henry and protect the public from future wrong. We do believe the joint and recommended sentence is appropriate. We ask the court to consider it at this time. We also ask the court to consider waiving any mandatory fines, as Ms. Henry will be likely incarcerated for at least 3 years pursuant to the plea agreement. And obviously, her being able to pay those fines would be near impossible, so we ask the court to consider those.
And Ms. Henry, anything you'd like to say?
I'm sorry.
Is there anything you'd like to say before announcement? You're not required to say anything, but if you'd like to say anything on your behalf you'd like me to consider, I'll be glad to hear.
I'm sorry. I know I've done wrong. I'm sorry.
Were you working before you were arrested in this case?
No.
Do you own any real estate?
No.
Do you own anything besides the 87 car?
A Denali. It don't run.
And do you have any income or property of any type?
No.
Alright. Well, in regard to case number 22 CR 12, it's the order of the court that should be and are hereby sentenced to the Correctional Reception Center in Ohio for a period of 6 months. I'm sorry, to the High State Court for Women at Marysville, Ohio, for a period of 6 months. And in case you were arrested on February the 14th on that charge, you've been in jail since that day. Was that the date you were arrested?
Yes.
All right, so that would be 57 days of jail time credit in that case. In case number 22 CR 43, as to count 3, it's the order of the court that should be sentenced to the High State Court for Women in Marysville, Ohio, to a mandatory term of 3 years, which could be extended by the Department of Rehabilitation and Corrections at their pursuant to their authority under law to 4.5 years. And it's also ordered that it should be sentenced to a period of 36 months on count 5. The sentences in this case, count 3 and 5, are run consecutively to each other and also consecutively to the sentence imposed in 22 CR 12. The court finds that its offenses were created as 2 or more separate courses of conduct, and that there are distinct transactions or incidences to each of these counts, and that one single sentence would not adequately reflect the seriousness of the defendant's conduct, and the sentences that are being imposed are not disproportionate to the harm caused. And because of the conduct, these offenses, criminal conduct history is such that the court feels that consecutive sentences are necessary for their public. Yeah, it's not often I get somebody who has a clean record come in here with a first-degree felony. It's unfortunate you decided to get involved in such serious offense, as a novice, I guess, for lack of a better word. But, you've done it, and, the consequences are there, and obviously you understand it. But that, all those be ordered so served consecutively, and since you were already in jail, actually, I guess you were picked up on both counts at the same time, so the sheriff gave all the credit to the first one, so it doesn't matter which way it goes. So you have no jail time credit in 22 CR 43. The order, now, upon completion of the prison term that's been imposed by the court, as to count 3 in 22 CR 43, you will be placed in post-release control for a period of at least 2 years and a maximum of 5 years. As to count 5 in 22 CR 43 and as to the sole count in 22 CR 12, it is optional. That is to be up to the board, the parole board, to determine whether they will put you under supervision in that case, in those cases, as well as the count 3. And if they do, it will be up to 2 years on each of those. Now, if during the period of time that you're being supervised, the parole board determines that you have failed to comply with their conditions, then they have the right to return you to prison to serve an additional period of up to 9 months for any one violation, up to a maximum of half of the prison term that was imposed. And so in this case, that's 6.5 years. And so it would be 3 1/4 years. I guess it'd be 3 years and 3 months. However, if you committed a felony while you're under post-release control, then in addition to whatever sentence the judge in that new case can impose, that judge will also be authorized to sentence you for committing that crime while under post-release control in these cases to an additional period of 1 year or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. Now, you're also ordered to pay the court cost in each case which judgment granted execution is ordered. And if you fail to do that or make payment arrangements, then the clerk will collect that through various means, including levy on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then once you complete your prison term, not while you're in prison, but once you get out of prison, you will be permitted to do community service in this county and be given credits for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment on that amount until paid in full. Given the length of the sentence and the fact that the court has examined the defendant as to her ability to pay the mandatory fines, court finds that she does not have the ability to pay the fines and is not likely to have in the near future. Therefore, the court will waive the mandatory fine in counts 3 and 5 and 22 CR 43. 22 CR 12 is optional. It's not imposing a fine in that case and is not imposing any jail or any driving suspension in any of the 3 counts. All right, is there anything? Restitution's order in the amount of $1,320 in case number 22 CR 43 to the Huntington County Task Force. That is something that cannot be discharged in bankruptcy. It's a substantive order, so even once you serve every bit of time that you have could serve, it will still be there. It can't be discharged in bankruptcy, and you can be brought back to court to determine if you have the ability to pay, or it can be collected through other means. And that will be paid through the victim witness escrow account, and you will pay any service fee that's provided, required for providing that service. Now, is there anything further from counsel?
There you go.
No.
Raise your hand and custody, Ms. Henry.
Recording in progress. Recording stopped.
All right. Let's do Ms. Jones here first. Mari Jones. Okay, I'm still conducting a hearing here, so it'll be a few minutes before we get to you, so I'm going to mute my microphone so you don't have to listen to that. All right, case number 21 CR 161, State of Ohio versus Samaria, Alaki Jones. Present for the state is Justice Peter King. Present for the defendant's attorney Jacob Wagner. They are you, Samaria, Alaki Jones.
Yes.
Is that correct? Alaki, is that how you pronounce it?
I like
A lake? Okay, what's up? All right. Read that, read whoever that is. All right. Ms. Jones has entered a plea of guilty to aggravated trafficking and methamphetamine, a 5th-degree felony. The court referred the matter for a pre-sentence investigation. The court has received a report of which the attorneys had a summary.
State has one.
No, I'm not reviewed it, but I'm well versed in my client's criminal history, which is 0. We've met probably a dozen times. I approached the bench in the area now.
Yeah, I'm on another hearing, so if you would just leave it on mute, and then I'll notify you here in a few minutes. I'll be about 10 minutes probably. Yeah, I can hear you, but I'm having hearings here in courtroom, so if you would just mute when I'm ready, I'll let you know. Okay, thank you. All right. Anything from the state regarding sentencing?
Only was contained in the plea agreement, Your Honor.
All right, Mr. Wagner, anything you'd like to say?
Yeah, sure, I would. Normally I would just simply just follow the state's recommendation, but again, I think a little background would help the court here to go along with this recommendation. I would honestly say this is one of the bizarrest, I that's not a word, most bizarre, cases I've had in probably 21 years now practicing law. Only because she doesn't fit the bill, Your Honor. When Smart came in and we went over this, he and I commend her. She's been to my office like half a dozen times or more. She drives down with me. Long story short, Your Honor, it's my position. I think the evidence would show this would have been tried. She got wrapped up with an individual who was actually trafficking a hand-to-hand. It was a high school friend from Dayton. She knew they hooked up after graduation. She was basically, for lack of a better word, the Uber driver that was bringing this guy down here, and he was trafficking in methamphetamine. It doesn't belittle the fact that she was with him and culpable with complicity aspects, but she has zero record. I think a few speeding tickets at best. She's a single mom raising a 5-year-old little girl. She works. She just doesn't fit the bill. It's just horrible she got wrapped up with this guy. Because now she's sat out here with a felony. Again, and having her come to my office multiple times. The last time she was in, I'm like, well, we can try this thing. And she totally realizes she got wrapped up with the bad guy. She shouldn't have been driving down here. And she didn't want to take that risk. Again, I just hate it because she's young, she's sweet. I don't think I've ever said that about a client. But she just, it's horrible she's in the situation, Judge. I mean, she'll do the community control, it's not going to be a problem. That's it, sir.
Mr. Jones, anything you'd like to say? Actually, I see 8 traffic offenses. Most recent one was a seatbelt in January 21. It says your license was forfeited. Did you have a valid driver's license?
Yes, that day that I got pulled over is the day that all of this came about to. So he brought me a, I was actually pulling into my job when they put me
All right. Well, Ms. Jones, no question that your involvement was not the principal. Mr. Anderson is apparently a drug dealer, but I can't imagine why you would bring in a high school friend 65 miles from Trotwood down here to Hyman County and not know what it was for. And based upon what I've read in the PSI report about the narratives that were submitted in reports to the probation department, is that you knew that he was dealing drugs, and so that makes you an accomplice. And I think that the state has taken into consideration your lack of a prior record because you were facing charges that carry a mandatory prison term of 3 to 8 years and on 3 different counts. So you need to understand that no matter what kind of friend this person is, which is not a friend, they're going to involve you in something like this. So you need to be very careful about that in the future because if this happens again, you're not going to be walking, whether you're in front of this court or any other court. So it's the order of the court that you be and are hereby sentenced to a period of 3 years of community control under these conditions that will be under the probation department. And you're to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times. You must report when and as directed, be truthful in all statements you make, and answers you give to the probation department about your supervision conditions. You must keep them informed of your residence, place of employment all the time, and not change out without prior permission. Now, leave the state of Ohio at any time without prior written permission. May not enter upon the grounds of any correctional facility, nor may communicate or attempt to communicate with anyone who is an inmate or prisoner in this facility without prior written permission of your supervising officer. You're not permitted to purchase, possess, own, use, or handle, or control any kind of a firearm, ammunition, dangerous ordnance, or weapon of any type. And because of your conviction, it's an additional felony offense under both federal and state law for you to have any of those items. You are not permitted to purchase, possess, use, or have under control any kind of a controlled substance, drug abuse, CBD oil, trade, or any variant or analog of a controlled substance that has effects similar to a controlled substance, drug abuse, or any instrument, device, or thing that may be used to administer them or prepare them to be administered, unless you have a lawful prescription, a copy of which you must provide to your supervising officer within 24 hours of receipt. You're to submit to drug testing when and as requested by the probation department. You're not permitted to purchase, possess, use, or have under control any type of an alcoholic beverage. May not be present in any places where it's sold or being consumed, even if otherwise lawful. You may not associate with anyone as a co-defendant in this case, nor with any other person as a criminal record, as a member of a gang or a criminal group, or any person has the passion to in the future influence you to commit a criminal offense that violates these conditions. Thus, approved in writing by your supervising officer that applies to any family members that fall within that definition unless you're living with them legally before this crime is committed. After the date of this order, you're not permitted to marry or establish cohabitation, common law marriage type relationships with another without written permission. You report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law, not later than the next business day after that occurs. You must provide your supervising officer financial information and records of your ability to pay any restitution fees and costs for your review. You're referred by the probation department for any evaluation, assessment, any type of treatment, therapy, counseling, training, or other educational programming. You're to submit to that, and if there's any programming recommended, you're enrolled and successfully complete that. You'll be required to pay restitution in the amount of $2,450, and make monthly payment arrangements with the probation department. The court will order that be paid at $100 a month, beginning, today, I'll say July the 1st, and then every month after that. And you have to pay that before you get off paper, so that gives you about 26 months to do it. If you can't pay more, or if you have an income tax refund or something, you can pay that in advance with help. Because if you don't have it completed, your term can be extended to 5 years. Now, by being placed on community control rather than being sentenced to prison, you're deemed to consent to a search without a warrant of your person, residence, vehicles owned by you, or used by you, or any of the property places under your control where you're found at any time, any officer of the probation department. The restitution is we ordered $2,450 Highland County Task Force, joint several with co-defendants payable through the victim restitution escrow account, and you'll pay any fee associated with that. And you're also ordered to pay the cost of the subject order. If you fail to do that, the court could collect that through various means, including letter and bank accounts, wages, earnings, or other assets you may have. That doesn't collect it then, in addition to the other conditions, the court authority to do service, give you credit for each hour you work, and higher rates up to the court each hour you work, reduce your judgment by that amount to pay in full. Now, in the event that it's alleged that you have failed to comply with these conditions, the probation department can file a written notice out with the court. Court will set a hearing. You'll be given a copy of it, and you'll be entitled to have a hearing. If the outcome of that hearing is that you have failed to comply, then the court can revoke your community control at that time, sentence you to a period of 9 months to 36 months in the estimate provided by law, and a fine of $10,000. If that happens, then once you complete your sentence, the adult parole authority has the option to put you under post-release control for a period of up to 2 years. They don't have to, but they can. But if they do, they'll be supervised in the terms they set, and during that period of time they fail to comply, then they can return you to prison, make it serve an additional period, up to 9 months during one violation, up to maximum of half of the prison term imposed for all violations. But if your violation is a felony, then in addition to whatever sentence the judge in the new case imposed upon you, that judge is also authorized to sentence you in this case to an additional period of 1 year, whatever time left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively as sentenced in the new case. Now, Ms. Jones, and most likely, since you're still living in Trotwood?
Yes.
Most likely they'll transfer your probation to Montgomery County. And just let me give you a little heads up about that, because Mr. Anderson, you probably know other people that are in probation in Montgomery County where probation doesn't seem to mean anything until you've got half a dozen felonies or you've killed somebody. It means something in this one. If you don't comply, you come back here and it shows that you're not complying with these conditions, then you will most likely go to prison. So you need to understand that in this court, probation means something. It's not the same as Montgomery County. Even though they'll be supervising you, this court expects compliance and strict compliance. Now, you're no longer under pretrial supervision conditions, but you need to report to the probation department now at 117 East Main Street, here just down the street, as soon as you leave the courtroom, and they'll go over your new conditions with you. Anything further, Counsel?
There you are.
All right, thank you.
Thank you.
All right, Mr. Jones, good luck. All right. You want to do this? Yeah.
All right, now, all right, who is Mr. Green?
I am, sir.
You are, okay. All right.
I'm going to run, if I may, Your Honor, well, I can stay here or in the back.
You can stay here.
Okay.
All right. Let's see. All right, if you would unmute yourself there, please, Mr. Green? All right. Okay, this is case number 22 CR 68, State of Ohio versus Alan Green. Mr. Green is appearing by Zoom from the rehabilitation facility. His attorney is Jacob Wagner, present in the courtroom, as well as Assistant Prosecutor King. The defendant is charged with several counts, looks like 3 counts of aggravated trafficking and meth, and 3 counts of aggravated possession. And matter is set for this is a pre-trial, and I'm trying to find out, this is the final pre-trial. The trial set for April 28th. See that there has been a request for a continuance, Mr. Wagner. Wish to speak to that?
Yes, sir, if I may. No, this case was originally docketed, I believe, because Mr. Green was in the trial docket. He's since bonded out, he's down at the Massey house now. Spoke to Adam, his coordinator or supervisor at the Massey house. I was able to get down the plea offer and speak to Adam on the phone. At this point in time, we're still trying to work or resolve the case. In light of him being out in the program, Your Honor, the trial being less than 2 weeks away, we're asking the court for a continuance to keep working on the case.
All right. Mr. King?
State has no objection to the motion, Your Honor.
As far as discovery, it's all complete.
Yeah, I owe the state, Your Honor, it's going to be a nothing as far as there's no pretrial,
Right.
Fourth Amendment issues, nothing there.
All right. And Mr. Green, you're in agreement with your attorney's request that this case be continued?
Yes.
All right. Yeah, he'll get in touch with you. He still has some more hearings today. All right, set the matter for a final pretrial on May 4th at 1 p.m. That can be done by Zoom. Jury trial will be set for May 31st at 8 a.m. And the speedy trial time is continued, or is told, charged defendant under 29.5.72 All right, anything further then, counsel?
Zero.
Yes, sir.
All right, your attorney be in touch with you, Mr. Green. Thank you. All right, now, Mr. Lundy, you got unmute there, please? Oh, you're muted there, Mr. Lundy. If you could unmute, please. Yeah, there you go. I may have just accidentally muted you. All right. Case number 22 CR 55. State of Ohio versus Casey Kyle Lundy. All right. This is a Mr. Lundy's appearing by video from where are you located, Mr. Lundy?
St. George,
And where's that?
All
Alright. He's appearing by Zoom. His attorney is Jacob Wagner. He is present here in the courtroom. And representing the state is Assistant Prosecutor King. Since this is a plea, you think you need to be available by Zoom to talk?
We've spoken on the phone. I can be a case.
Let me ask you this, Mr. Lundy, since you're here by Zoom and your attorney's in the courtroom, and you're not available to sit next to him, if you think you need to talk with him, what I can do is he can go back in the jury room and get on his phone, and then he could I can put you in a breakout room for you to talk with him without anyone else seeing or hearing. Do you need to talk with him, do you think, here?
Not that I'm I talked to him the other day, said that everything's still the same.
All right. Is that right?
Yeah, and I have a letter from the rehab.
Okay, all right. All right, so if you change your mind, just tell me, and I can take a break, put the two of you in the break room so you can talk to each other, okay?
Okay.
All right. So, Mr. Lundy is charged along with Dusty Allen Hale with breaking and entering, theft, 2 counts of theft. One theft is a misdemeanor, the other theft is a quick history felony, so it's a B&E. This matter is set trial on May 31st. And I've been presented with a plea of guilty form, Mr. Lundy, which says you're going to withdraw your not guilty plea and plead guilty to count 1 felony of B&E. And this form is 3 pages long and been prepared by the prosecutor's office. I see the signatures of the attorney on page 3. On page 3, just not quite halfway down, there's a sentence that says, I enter this plea voluntarily. Right below that, there's a signature line that says, above that, it looks like a signature of Casey Lundy. Is that your signature I'm looking at here? And let me hold that up to the camera so you can see it. That's your signature. All right. When did you sign this agreement, Mr. Lundy?
I believe it was Friday.
All right. And did you talk to your attorney and have him go over that with you and explain everything to you before you signed it?
Yes, sir.
And when you signed this, did you understand that it's an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case will be a sentencing hearing?
Yes, sir.
And do you feel that you had enough time to fully consider this matter before making this decision?
Yes, sir.
Do you feel that you've been rushed or pressured in any way into doing this?
No.
And even though you signed this last week, you're still of the opinion you want to go forward with it here today on Monday, April 11th?
Yes.
All right, now the agreement says you're going to plead guilty to count 1, which is breaking and entering under 2911.13a revised code, a 5th degree felony. Further states that you understand that the maximum prison term for that could be 12 months, minimum would be 6 months. There could be a fine of $2,500. Do you understand that?
Yes, sir.
Are you facing any felony charges in any other jurisdiction?
No.
Are you currently on probation, community control, parole, or post-release control from any jurisdiction?
Yes, sir.
And where's that?
Warren County.
What is the charge or sentence in there?
I believe it was, I got a lot for no conviction, and it was I believe the same exact charges.
Okay, so you're on an intervention in lieu of conviction?
Yes.
Okay. Well, under the law, I don't know when that offense occurred, but under the law, if you're convicted in this case, that could potentially result in that being terminated. And if at any point in the future it's terminated and you should be sentenced to prison from both that county and this county, those sentences could be ordered to be served consecutively, meaning one after the other on top of each other. Do you understand that?
Yes, sir.
All right. Now, under the law, if you are convicted and sentenced to prison, then upon completion of that prison term, the law provides that the adult parole authority has the option, if they choose to exercise it, to put you under post-release control for a period of up to 2 years after you're released. And if they do that, you'll be supervised on the terms they set, and if during that period of time they allege that, or they find that you have failed to comply, then they can return you to prison and make you serve an additional period of up to half of your prison term for 1 or more violations. But if you commit a new felony, then in addition to whatever sentence the judge in the new case would impose upon you, that judge is also authorized to sentence you in this, for committing that offense while under post-release control in this case, to an additional period of 1 year, or whatever time would be left on the post-release control, whichever is more. As that occurs, that will have to be served consecutively to the sentence in the new case. You understand that?
Yes, sir.
Under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control or probation, which means that instead of going to prison, you can go under supervision of a probation officer for a period of up to 5 years, under the term set by the court. And if during that period of time, probation felt that you were failing to comply, then they would file a written notice out to the court. You would be given a copy of it. You would have a hearing, be entitled to have an attorney. If the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control and then sentence you to prison or 12 months, fine $25. You understand that?
Yes, Your Honor.
Right now, the charge alleges that on or about, let me get here, December 14, 2020, Highland County, Ohio, you and Dusty Allen Taylor did knowingly by force, stealth, or deception, trespass in an unoccupied structure toward an outbuilding with purpose to commit therein a theft offense as defined in ORC section 2913.02A1 or felony, violation section 2911.13A. So that's the charge of breaking in. Now, do you understand what it is you've been charged with, what the state said you did, or how they let you get it?
Yes, Your Honor.
Do you understand the possible sentence for this offense?
Yes, Your Honor.
Have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, the possible defenses you try to raise in trial, and the possible outcomes of the trial with your attorney?
Yes, Your Honor.
Are you satisfied with his advice and confidence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Are you taking any prescription drugs there at the facility?
No, Your Honor.
Have any threats been made against you to plead guilty here today?
No, Your Honor.
Now, on page 2, about 3/4 of the way down, there are several lines printed in bold and underlined, so I will read those at this time. Defense shall enter plead guilty to count 1. State will dismiss the remaining counts. State defense jointly recommend committing control and continue with current substance abuse treatment. Defendant agrees to make restitution of Pax P in the amount of $1,652.06. Defendant agrees to make restitution of court piece of truck equipment in the amount of $1,762.81. Restitution to be paid in full in sentencing. Defendant agrees to cooperate fully in the prosecution of the defendant. Now, is that your understanding of the agreement?
Yes, Your Honor.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, Your Honor.
Now, under the law, Mr. Lundy, the matter of sentence is up to the judge, not to the parties. And so even though there's a recommendation from both parties that you get community control or probation, once I've heard all the information that's submitted to me, I'm not required to follow that recommendation. I could decide that you should get a prison term between 6 and 12 months and fine $2,500. You understand that?
Yes, Your Honor.
And Mr. Wagner, the amount of restitution is agreed to, is set forth in this agreement.
You're stipulating it, yes.
And so that appears to be about a little over $3,400, and it says that you're going to pay that prior to sentencing, which would be about 30 or so days. Are you going to be able to do that, Mr. Lundy?
Yes, Your Honor.
Okay. Because I don't want you to agree to something you're not able to do. But you're going to be able to make that payment.
Yes, sir.
All right. Now, do you hold any license or certificate from any state agency that regulates any occupation or profession?
No, I don't believe so.
That'd be like a pharmacy tech or veterinary tech or barber or stuff like that, where you have to take an exam and get a license from the state.
No, Your Honor.
Okay. Now, you have certain constitutional rights, which understand before I can approve this agreement. First of all, you have a right to counsel. Mr. Wagner was appointed to represent you, not simply to work the case out, but to provide any defense that might be available to you under the law that you wish him to provide. So, if you decide that you do not want to do this, you it will still defend you, including trying the case, if that's what you want to do. You understand that?
Yes, Your Honor.
Under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be chosen from a group of citizens that live in this county that are summoned for jury duty on your trial day. After they are selected, the evidence will be presented, and then they would be instructed on the law by the judge, and they would decide by unanimous verdict, meaning all 12 of them have to agree, as to whether the state proved your guilt by proof beyond reasonable doubt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial. In that case, you'd have to hold a court or bench trial, which means that the jury would be the one to hear the evidence instead of the judge. The jury would apply the law. The judge would hear the evidence instead of the jury. The judge would apply the law, and the judge would be the one who would decide whether or not the state proved your guilt. You understand that?
Yes, Your Honor.
Right, under the Constitution, you have the right to confront witnesses against you and to cross-examine through your attorney. What that means is witnesses against you have to come into court, testify in front of you, and your attorney and anyone else present. Once the prosecutor's done asking questions, your attorney asks questions, that's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. You understand that?
Yes, Your Honor.
Now, under the Constitution, Mr. Lundy, you have the right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're not certain going to come in voluntarily, at your request, the court issues a court order called a subpoena. Now, of course, those witnesses to come to court be able to testify if you want them to, even though they didn't want to be here, which is the same way the state's witnesses are required to come to court. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide you're not going to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. No one's even allowed to talk about it, except one situation, which is if there's a jury trial and you cannot testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Right, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio in every essential element of the offense charge. So what that means is the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence in your defense. You may, but you're not required to. Whether you do or not, the burden of proof will always be on the state of Ohio to prove your guilt on every essential element of the offense charge by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes, Your Honor.
All right, now originally entered plea not guilty, Mr. Lundy, that plea denied the allegation of the indictment, denied you committed any crime, and exercised or invoked all the rights I just described. Change your plea from not guilty to guilty to count one, that's the opposite of not guilty plea. That plea waives all the rights I just admits that she did what's alleged and that it's a crime. And that plea waives gives up all the rights I've just described except the right to have an attorney, which you always have no matter what you plead. Without accepting your plea of guilty, waives gives up the right to a jury court trial, waives gives up the right to confront witnesses against you and cross-examine your attorney, waives gives up the right to confront witnesses against you in open court, cross-examine your attorney, waives gives up the right to use the power of the court to compel or force witnesses to come to court and testify for you, the same as the state, waives gives up your privilege against self-incrimination because you're saying you're guilty, that's what she defines guilty, waives gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. Finally, waives gives up any right to file an appeal, which you think you may have had up to this point in the case. Now, if I sentence you to the maximum sentence or under certain circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing after being filed. Do you understand all of that?
Yes, Your Honor.
And are you a U.S. citizen, Mr. Lundy?
Yes.
And are you entering into this agreement to plead guilty voluntarily?
Yes, Your Honor.
Now, do you have any questions about the charge and possible penalties?
No.
You understand?
Yes, sir.
Any questions about the plea agreement?
No, Your Honor.
You understand?
Yes, sir.
And again, you understand the recommendation as to sentencing is not binding on the judge.
Yes, Your Honor.
Now, do you have any questions about the constitutional rights I've explained to you?
No, Your Honor.
You understand those?
Yes, sir.
Any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, Your Honor.
You understand?
Yes, sir.
Do you think there's anything you need to talk to Mr. Wagner about before we go any further?
No, not that I'm aware of.
Do you have any questions about anything I've explained to you here?
No.
Then is it your decision, Mr. Lundy, to withdraw your not guilty plea, plead guilty to count one under the terms of the written plea agreement that I've just gone over?
Yes, Your Honor.
Then as to the charge in count one, which alleges that on or about December 14, 2020, Highland County, Ohio, that you and Dusty Allen Taylor did knowingly by force, stealth, or deception trespass in a non-occupied structure to wit an outbuilding with the purpose to commit their theft offense as defined in RC section 2913.02A1 or a felony. In violation of section 2911.13A, charge of breaking, entering, and fifth degree felony, carrying a possible prison term between 6 and 12 months and a fine of $2,500. How do you plead? How do you plead?
Oh, guilty.
All right, thank you. All right, the court finds that on this date, open court defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to criminal 11 pleas accepted in order of I assume you don't have the money to pay the restitution today.
Yes, it'll be here.
Okay, well,
Your Honor, I've contacted family, the money is going to be paid.
okay. Well, I'm gonna, set this sentencing off for a little while, because I do wanna have a pre-sentence investigation. I know there's not one requested, but I want to know a little bit more about what's going on over in Warren County and his background. And so we will set the sentencing hearing for, June 1st at 9 a.m. How long have you been there sojourner, Mr. Lundy?
I believe, 14 days.
All right, so you're scheduled to be there for what, at least 90?
If I may,
30 to 45 they recommended.
Oh, okay.
And I have to do, things probation and on house arrest.
All right, and I don't know if we have a holder on you or not.
Mayor, if I may?
Yes, go ahead.
Mayor, I've got a copy of, if I can get to the court or run a copy of the admittance letter and also the order out of Warren County from the judge who's got him under detention up there, so I got them both.
Well, just make copies of that and get the probation officer.
Yes, sir.
You can leave it with the bail and get one.
Yep, we got contact numbers here.
Okay. I'm just looking here. Yeah, actually, he's under a $2,500 bond, so, that was actually a hold on him. So I'll tell you what happened, once you get closer to his discharge, you can talk to the facility, I want to see what's going on with his treatment, where he's going to be living and supervised, and at that point, I would entertain a motion to, convert that to an OR bond, but they'll have to come back here and sign.
Yes, sir. I could be wrong, his father may have posted that bond number.
Oh, really? Well, let's look here. I just assumed since he was down there.
Because he had a order out of Warren, he posted it, took him to Warren, and he went straight from Warren to the program.
Oh, okay, well, let me look here. I see the OR, but I don't see the bond. I see, yeah, I did a bail review on March the 8th and continued it, which was 2,500. And then on March 16th, there's no OR file. But I don't think there's a, I'll look to see maybe it was a, oh, that's the last thing I have. So according to the file, he still has to provide $2,500. Now, if he's provided it, maybe it didn't get put in the file. So you might want to check the clerk's office and see.
I'll call his dad, too.